Hi, I'm Patrick Ritchie, and in today's webinar, we're going to talk about the Dodd-Frank ability to repay. The ability to repay went into effect on January 10th of 2014, and the standard is designed to make sure that lenders are only giving loans to people who can afford them. And the whole goal is really to avoid the financial collapse that we saw happen at the end of 2007 into 2008. So it requires creditors to make a reasonable, good faith determination of a consumer's ability to repay. Are they able to qualify and legitimately pay back the loan and pay back that money that they've borrowed? So it applies to consumer credit transactions secured by a dwelling. So we're talking mortgages. There are some exemptions to the rule. Not all transactions would fall under this, but the majority of mortgages would. So how does this impact a lender? Well, first of all, there's liability for the lender that we've never seen before. A borrower could potentially bring an action against the lender for giving them a loan that they're not able to afford. Now, there's a lot that the borrower would have to prove in order to prevail in that action, but it essentially sets the stage for a borrower to go after a lender for the costs, the interest, stuff of that nature, attorney's fees, for giving them a loan that they did not, without a shadow of a doubt, make sure that this person could actually afford. So if the lender does not abide by the requirements of the ATR, of the ability to repay, that's when an action could be brought against that lender. But the lender could reduce their liability by staying within the requirements of what's called a qualified mortgage. So you've got a qualified mortgage, which adds another layer of standards, not just the ability to repay, which is more focused on verification to make sure that this person can afford it based on their income and their assets and their credit, stuff of that nature. The qualified mortgage takes it a step further to kind of create more of a safety net for the type of loan that's being made to a borrower. And if a lender abides by that, then they're actually adding some safety to themselves in terms of protecting themselves from liability. So assuming that the lender abides by the ability to repay, there is further protection from legal action by being qualified mortgage compliant. So the QM, or qualified mortgage, the safe harbor reduces the liability for the lender. As long as they've met the requirements of a qualified mortgage, they're presumed to have made a good loan. They're presumed to have met the requirements of the ability to repay. And at that point, the borrower would have to prove that that lender did not abide by the ability to repay, that they did not make a good faith, reasonable effort to make sure that this borrower is able to repay that loan. So the basic qualified mortgage requirements for a lender, the first part would be that it's not a high-cost loan. Now, a lender could make a high-cost loan, and it's a formula that the Consumer Financial Protection Bureau put together, but a lot of loans are not going to be high-cost loans. And even if they are, they could still fall within certain protections. But in a qualified mortgage, it's not a high-cost loan. And there's no risky features. The risky features are really what the Consumer Financial Protection Bureau have identified as the biggest detriment to borrowers during the crash and what caused a lot of the foreclosures and short sales. So some of those risky features include negative amortization, which is when you are making a minimum payment, but you could actually have a growing balance because that minimum payment is less than the interest due. So that's negative amortization. So that falls under this risky feature that the CFPB has identified. And sometimes you might hear these risky features termed as toxic features. So it's an interchangeable term, but it means the same thing. Or interest-only payments, where somebody's only paying the interest due, but not actually knocking down the principal owed. Two other risky features would be balloon payments, which there are some exceptions to in terms of smaller creditors. There's some different rules there. And also potentially with seller financing. So you could still see balloon payments on the market and it may just depend on the size of the lender and specific requirements. But for the most part, the CFPB does not like to see the balloon payments because it can be a shock to somebody if all of a sudden they have to pay back a full balance within 5 to 10 years rather than over a 30-year term. So balloon payments fall into that category. And then any term that's actually exceeding 30 years would also be considered a risky feature for that qualified mortgage. And so it's also going to look at the debt to income ratio. So the back end debt to income ratio is supposed to not exceed 43% in order to be a qualified mortgage. That is, unless it has been approved for delivery to Fannie Mae or Freddie Mac for the conventional loans, which are your government-sponsored entities, and assuming that you're getting an automated approval through their underwriting system, whether it's desktop underwriter or loan prospector. And then same thing with FHA, VA, or USDA. You could be getting an automated approval, or it's possible also that you would be getting a manual underwrite approval where it at least meets the guidelines so that FHA is insuring it, VA is guaranteeing it, USDA is taking that loan. So if it has an automated approval and it goes above 43%, that's generally going to be acceptable. And that's going to be the case up until at least 2021, and then that could change at that point in time. But the reality is 43% is what is required for a qualified mortgage, but you could go higher than that with an automated underwriting approval. So that's important to be aware of. So a lender could still do a non-qualified mortgage, but there's just going to be less protection from liability if they do a non-QM loan, which more and more lenders are starting to do. And so, they're kind of sidestepping a little bit of the protection that's there, but it just kind of depends. I mean, there's still protection. It kind of depends on the appetite of that lender of how much risk they want to take. So back to the ability to repay. What is the actual standard? How is it that this law is saying a lender should look at an actual loan? Well, there's essentially 8 underwriting standards for the ability to repay. And the lender must make a reasonable and good faith effort to confirm these 8 standards. And the 8 standards are pretty straightforward. It's a lot of what you've already seen with underwriting, but let's go through them. Number 1, the borrower's current or reasonable expected income or assets. So what is the current income that they're qualifying for, and is there a reasonable expectation of its continuance? So if somebody's employed and they've got a 2-year history, whether it's on the same job, same employer, same position, same industry, if they've kind of got that standard history, or maybe they were in school and they've graduated and now they're working in whatever industry or field that they've studied, that's your general underwriting at play anyway. So it's looking at that. What is the likelihood of that continuing? So if somebody is in a temporary position, that could be problematic unless they have a really long history of always working in a temporary position. But in general, if somebody is in a permanent position, they're probably going to be fine. It's when there's uncertainty to that. If they've switched jobs a lot, if they don't quite have a 2-year history that can be pieced together, that may or may not be a problem. But that's the basics, is looking at the past and then trying to predict the future, that they likely are going to have that income. Now, that's just regular employment. You also have retirement funds that people could be living off of. So essentially you're looking at 3 years continuance on that. You could have disability income. You could have Social Security income. Are these forms of income, besides just employment, are they going to continue? Now, your general rule of thumb on continuance of an income that's non-employment based is going to be 3 years. Is that likely to continue for at least 3 years? So if they do that, then they're going to be fine. And then, of course, looking at assets, there's no specific to that in terms of what exactly you're looking at with assets, other than, of course, how much they need to close. And a lot of times with the automated underwriting, it may give some requirements in terms of reserves, but on its face, there's not a specific asset reserve requirement. Then number 2, the borrower's current employment status. Are they currently working? Are they in that temporary position? We talked about that. But are they switching jobs? Are they doing something completely new? analyzing that, looking at it from the likelihood that this is a position that they're going to continue, that they're going to have the income, the funds, and the means to make this mortgage payment. And that's really what it boils down to. All 8 of these requirements boil down to one thing. Is this person going to be able to repay this loan? And it's designed to make sure that loans are not being given to people who are not likely to make the payment and then ultimately would end up going into foreclosure and unable to pay that. So that's really what it's a protection against. Number 3, the borrower's monthly payment, the principal, interest, taxes, and insurance. So you've got your PITI, the PI being the principal and interest, and then you've got your taxes and your insurance. Now you've got homeowner's insurance in case the property were to be destroyed, that it can be replaced and rebuilt. But then you've also got mortgage insurance. Different mortgage insurances when somebody's putting less than 20% down. Ideally, if somebody is putting 20% down, they would just go conventional and they wouldn't have the mortgage insurance. But on FHA, you've got a pretty high mortgage insurance. It's a factor of 1.35, and it's there for the life of the loan. So it's expensive. And so, of course, in qualifying, all of those portions are going to be calculated in there. So you get your principal and interest, your taxes, and then your insurance, whether it's your homeowner's insurance or your mortgage insurance. So all of these things are being considered, and it's not just qualifying on like interest only or something like that. So it's designed to make sure that whatever that payment is going to be, whatever somebody's going to be writing a check for, it's designed to make sure that they're actually qualifying based on that amount. Number 4, borrower's monthly payment on simultaneous loans that a creditor knows or has reason to know will be made. So you've got your other loans, you've got student loans, car loans, credit cards, all sorts of different loans that are typically going to be found out based on what's on that credit report. You could have somebody who's had an inquiry on the credit report within the past 90 days, and maybe there's not a new credit account reporting yet. And so the lender's going to ask about the inquiry to say, has there been a new account that's not being reported yet? Because we have to count that, in the calculation to make sure that you can actually afford it based on this debt to income ratio that you're going to be approved at. But also, if a borrower mentions in passing, oh, well, I pay $400 to my brother-in-law for the vehicle that I'm driving. While that's not something that's going to be on the credit report in all likelihood, that's something that the lender should be counting in the debt to income and the back end debt to income ratio, because if it's an obligation, if it's a debt, it's supposed to be counted because it does come into play in terms of whether or not somebody's going to be able to afford to make that mortgage payment. So if they're aware of it or should have been aware of it, then it has to be counted. So that's the important thing there, is to know that any payments that they're making on debts, this is just for debts, not services, stuff like that, just pure debts, they have to be counted. Number 5, borrower's monthly payment for mortgage-related obligations. Now that could stretch beyond the regular PITI to HOA dues. It could be flood insurance. Flood insurance is a possibility. If there's HOA dues or neighborhood associations, stuff like that, that's part of the housing. That has to count as well and be added to that PITI. Even though that's not part of their mortgage payment, it's part of the obligation to maintain that property, that home. It's going to have to be counted. So any other debts that may exist surrounding that particular property, that's going to be a part of the equation as well. And number 6, borrower's current debt obligations. That would not just be loans that people have, but it would be alimony, child support, stuff of that nature. There could be an issue, where there's some collections, and those are going to be treated on a case-by-case basis, depending on the age, depending on the current status. Is it a charged-off account? Is it not a charged-off account? Is it something like where it's a municipal collection that might be more collectible than something that's just a medical collection? So they're going to look at all these different scenarios within a credit report to see the debts that are owed, whether they're currently being paid on or not. It could be a situation where maybe a portion of that debt has to be counted, maybe 5% of a balance is counted. And then also on the flip side, sometimes it's not going to be counted. It just depends on how it's reporting, what is the status of that debt. And, once again, kind of a case by case basis, but probably more so than in the past, you're going to see some of these debts counting where at other times in the past they haven't. Number 7, the borrower's monthly debt to income ratio, the DTI. Analyzing that. We talked about on a qualified mortgage that it's not supposed to exceed 43% unless you have an automated approval from either Fannie Mae or Freddie Mac while they're under government conservatorship. They actually get a pass just like FHA and VA and USDA, where if you have an approval from one of those entities, you can exceed 43%, and that's going to run through 2021. So if Fannie Mae and Freddie Mac come out of federal conservatorship, then at that point in time, that 43%, going above 43%, would actually cease at that point in time unless the law is amended. So could somebody be at 52%? Yeah, they actually could if they have an automated underwriting from one of those programs, whether it's conventional with Fannie Mae or Freddie Mac, whether it's FHA, VA, or USDA. Now, USDA usually keeps the debt to income ratios pretty low anyway, so you're not going to see it generally go that high. FHA and VA, different story. They can go fairly high. I've seen both of those go up into the 50% range, but they're always kind of changing around the automated underwriting and trying to keep, sometimes you might see one go higher because somebody has a high FICO score or because they have a lot of reserves and assets. It varies. It's always a tailor-made approval, but if they get that approval, they could exceed that mandate of 43%. And then number 8, the borrower's credit history. So it's not specific in terms of an actual required FICO score. You'd probably default to FHA's requirement, which is a minimum of 580 on the maximum financing, but it's not specific per se in terms of you have to have this FICO score. It's just more of, in looking at that history, is it a reasonable expectation that this person is going to be able to perform on this based on their previous history? And so the credit's going to be looked at. They're going to look at the credit report. And generally the rule of thumb is, you're looking for generally 3 pieces of credit that have been paid on time for the past 12 months. Not to say that somebody couldn't get by with just 1. It happens. And, maybe it's 2. And in some cases, people might even be able to get non-traditional credit where they have no FICO score at all. They could do that under FHA. And that's going to vary from lender to lender. But looking at the credit history, looking at that, because you're going to see debts that are owed, you're going to see the payment history, and kind of get a gauge of whether or not this person is going to be responsible in making repayments on that mortgage. So that's number 8. So these standards are already pretty common in underwriting protocol, but when you think back to prior to the crash, when you saw a lot of no documentation, you saw stated income, stated asset type loans, no ratio loans, those loans were looking at a certain strength, and maybe that strength was just a really good FICO score, but not proving income, or maybe it was showing good income but not real strong credit scores, or maybe it was just ignoring everything altogether and just basing it on really strong assets. So it was different combinations of things. So this is a more equally distributed consideration of whether somebody can qualify or not, looking at the income, looking at the assets, looking at the credit, and then making a determination. So much different than what we've seen in the past, but also what we've always kind of seen on standard conventional government mortgages, but we started straying away from that once we kind of got into those subprime and alternative type programs. So what transactions does this actually apply to? Well, it's going to be primary residences and then any second homes or vacation homes. Those types of dwellings securing the mortgage, that's where the ability to repay will come in to be an issue. But you have exemptions. HELOCs, your second mortgages, those home equity lines of credit, those are going to be exempt. Reverse mortgages are going to be exempt. Timeshares are going to be exempt. And also bridge loans and construction loans with terms of 12 months or less, those will be exempt as well. Investment properties are exempt if it's for business purposes, but the borrower will have to sign a letter acknowledging that they're not going to reside in that property for more than 14 days out of the year, because if they are, under the federal law, it would then, if they were going to be in it for 15 days out of the year, it would be treated more as a second home than it would be as a investment property. And so at that point, the ability to repay would actually apply. So basically what all of this does is it takes us back to, just to the basics, of what underwriting typically has always been, and kind of just removes some of that danger of giving a loan to somebody who doesn't really qualify to repay that. So it's a preventative measure. It's to protect consumers. It's to protect, the markets, to protect the economy, to protect everybody as a whole. But it's important to understand what's in play there, in terms of how lenders are looking at that. So hope you found this useful. Join us next time for the next webinar. I'm Patrick Ritchie with the Credit Literacy Project. I'll see you in the next module.